Distinguished participants, dear colleagues, dear friends, international criminal justice is a necessity for Africa. The reason is simple. Numerous international crimes are committed on African soil. Numerous Africans have been, still are, and will become victims of atrocities that shock the human conscience. To do justice to these victims, Africa must join the global battle against impunity and hold perpetrators criminally accountable. Indeed, many African states have joined the global effort to end impunity. They have supported the United Nations International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, and African states form the largest regional bloc in the ICC's Assembly of State Parties. Yet, as we all know, Africa's relationship with those exercising international criminal justice against African leaders has been difficult. In particular, the relationship between Africa's regional body, the African Union, and the ICC has not been an easy one. The ICC has been accused of targeting Africans. Initially, the critique was quite modest, but when the ICC initiated cases against African political leaders, notably Presidents Omar al-Bashir of Sudan and Uhuru Kenyatta of Kenya, the African Union condemned the ICC. In my presentation today, I will not focus on the ICC cases or on the debate whether Africa is a participant or target of international criminal justice. What I would like to focus on are the implications of the AU stance. More specifically, I would like to focus on alternatives for ICC prosecution. One such alternative is the creation of a criminal chamber within the African Court on Human Rights. Another alternative is universal jurisdiction. My presentation today will reflect on universal jurisdiction. As we all know, universal jurisdiction allows states to claim criminal jurisdiction over an accused person, regardless of where the alleged crime was committed, and regardless of the nationality of the accused, country of residence, or any other relation with the prosecuting entity. Crimes that can be prosecuted under universal jurisdiction are those crimes that are so grave and so heinous that they do not only offend the people of the local community where the crimes were committed, but they offend humankind as a whole, and as such are crimes against the international community. These crimes include genocide, war crimes, and crimes against humanity. The recent case of Rwandan intelligence chief, Lieutenant General Karenzi Karake, arrested in London at the request of Spanish prosecutors, does not seem to be covered by the notion of universal jurisdiction. The Peace and Security Council of the African Union condemned the arrest as yet another example of abuse of universal jurisdiction by European states. This allegation seems to be incorrect. Karake is accused of having been involved in the killing of 3 Spanish medics in the aftermath of the Rwandan genocide. Hence, this would seem to be an alleged ordinary crime falling under nationality jurisdiction, not universal jurisdiction. Universal jurisdiction was the key feature of the evolving regime of international criminal justice in the 1990s, but was pushed somewhat to the background after the fall of the famous or infamous far-reaching universal jurisdiction laws of Belgium, and especially after the establishment of the ICC. Universal jurisdiction seems to have regained popularity and is back on the international justice agenda. The Zimbabwe torture docket, launched in South Africa last year against Zimbabwean officials for alleged international crimes committed during the March 2007 elections in Zimbabwe, is an example, as is the Habre case before the extraordinary African chambers within the courts of Senegal. An African solution to an African problem, it would seem. The Habre trial is being conducted at the request of the African Union, which appears to favor the exercise of this extraterritorial jurisdiction in Africa. A few years ago, the Executive Council of the African Union recommended the adoption of an African model national law on universal jurisdiction over international crimes. This may come as a surprise. AU organs in numerous declarations and communications have condemned the exercise of universal jurisdiction. However, the point of critique always concerned the exercise of universal jurisdiction by European courts over Africans, and more specifically, African state officials. It is, in fact, only in that specific context that the AU has spoken of abuse of universal jurisdiction. In fact, the AU has even endorsed the view that universal jurisdiction is a principle of international law. The model law covers additional offenses such as trafficking in narcotics and terrorism. Further, the model law expands the definition of genocide by including acts of rape that are intended to change the identity of a particular group. Also, the model law provides for universal jurisdiction not only over principal offenders, but also over aiders and abettors, accessories before and after the fact, as well as those who participate in conspiracies to commit those offenses. In 2014, the African Union, at its 23rd Ordinary Session in Malabo, Equatorial Guinea, adopted the Protocol on Amendments to the Protocol on the Statute of the African Court of Justice and Human Rights, the Malabo Protocol. The Malabo Protocol, like the model law, contains elements, principles that Africa Legal Aid advanced more than 10 years ago in the Cairo-Arusha Principles on universal jurisdiction in respect of gross human rights offenses, an African perspective. The additional offenses, besides the classic international crimes, genocide, war crimes, crimes against humanity, including piracy, covered under the Malabo Protocol, include the crime of unconstitutional change of government, terrorism, mercenarism, corruption, money laundering, trafficking in persons, trafficking in drugs, trafficking in hazardous wastes, illicit exploitation of natural resources, and the crime of aggression. The Cairo-Arusha principles adopted under the auspices of Africa Legal Aid have been coined the voice of Africa on universal jurisdiction. They were cited in Judge Christine van den Wijngaard's famous dissenting opinion in the arrest warrant case before the International Court of Justice between the Democratic Republic of Congo and Belgium. The arrest warrant case before the International Court of Justice between the Democratic Republic of Congo and Belgium. The African model law on universal jurisdiction seems to favor universal jurisdiction and approaches the topic from an African perspective. One may regard this as positive, but there is a caveat also found in the Malabo Protocol, a caveat that is not in the Cairo-Arusha principles. One of the aims of the model law is to give effect to immunities enjoyed by foreign state officials under international law. Similarly, the Malabo Protocol under Article 46A grants immunity to heads of states and government and senior government officials. According to the AU, the immunity provisions is consistent with its policy of sequencing peace and justice. Proponents of the immunity provision argue that removal of a head of state without fully providing for how the transition will be managed would lead to collapse of law and order. As well, they argue that in the context of universal jurisdiction, immunity for senior state officials before foreign courts is part of customary international law. On the other hand, opponents of the immunity provisions argue that the provisions are self-serving, meant to protect African leaders who wish to avoid prosecution anywhere, and demonstrates once more that their main concern is to ensure that they themselves can escape the wings of criminal justice. Nonetheless, the fact that a model law on universal jurisdiction is being developed within the African Union framework demonstrates the significance and potential of universal jurisdiction. At the very least, it is relevant for the development of opinion juris among African states in pursuance of universal jurisdiction. Of course, much needs to be done to make universal jurisdiction practically meaningful. And we have to be honest, there are obstacles. Financial obstacles, lack of capacity, and perhaps a lack of political will. These will not always be easy to overcome. Yet, the trend I observe is that there's increasing awareness that universal jurisdiction, next to national prosecutions and the ICC, can contribute to providing justice for the far too many victims of international crimes on the African continent. Thank you.